Okay, it's nice to be back. It's nice to be back on air after 15 days na walang upload. But anyway, for this video, we will be talking about the void and voidable marriages. Yung void, yung hindi siya valid na kasal, and yung voidable marriages, ito yung valid siya pero valid until annulled. Meron din tayong tinatawag na void ab initio. Not valid from the very beginning. So under our family code, under article 35 of our family code, diniscuss dito yung mga void marriages. So the following marriages shall be void from the beginning. Those contracted by any party below 18 years of age, even with the consent of the parents or the guardians. Why? Because one essential requisite of the contracting party in a marriage, that she or he should be of legal age. And as we all know, that of legal age to us is 18 years old. So below 18 years old, who contracted marriage, it is a void marriage. Second is those solemnized by any person not legally authorized to solemnize a marriage. Void marriage din yan. Sa mga hindi po nakapanood ng mga naunang video, pwede nyo pong balikan yung mga video. For those people, for those authorized person to solemnize marriages. Well, of course, there is an exemption to the person na hindi authorized to solemnize marriage. Like for instance, the contracting parties believing in good faith that the solemnizing officer is authorized to solemnize a marriage, or the solemnizing officer has the authority to do so. That is the exemption. Kapag walang authority yung solemnizing officer. Third is those solemnized without a marriage license, except of course those covered sa ibang articles ng ating family code. Just for example, when you're living together as husband and wife without the benefit of marriage for more than 5 years, you are exempt to secure a marriage license. But absent any marriage license, your marriage is void as a general rule. The fourth one is those bigamous or polygamous marriages not falling under Article 41 of the Family Code. Under Article 41 of our Family Code, a marriage contracted by any person during the subsistence of previous marriage shall be null and void, unless before the celebration of the subsequent marriage, the prior spouse has been absent for 4 consecutive years and the spouse present had a well-founded belief that the absent spouse was already dead. In case of disappearance, where there is danger of death under the circumstances set forth in provisions of Article 391 of the Civil Code, an absence of only 2 years shall be sufficient. For purposes of contracting the subsequent marriage, under preceding paragraph, the spouse present must institute a summary proceeding as provided in this code for the declaration of presumptive death of the absentee, without prejudice to the effect of reappearance of the absent spouse. Yun ang Article 41. So, kapag wala yung asawa mo for more than 4 years ba yan? So for purposes of contracting the subsequent marriage, under the preceding paragraph, the spouse present must institute a summary proceeding as provided in this code for the declaration of presumptive death of the absentee without prejudice to the effect of reappearance of the absentee. So you can contract a subsequent marriage even there is no declaration of nullity of your marriage to your first marriage. If you have a well-founded belief that your husband is already dead, you need only to file a summary proceeding to the regional trial courts to declare your husband absent for purposes of contracting a subsequent marriage. When I say subsequent marriage, pangalawang kasal mo sa iba na alam mong kasal ka sa una. The number 5 as a void marriage is those contracted through mistake of one contracting party as to the identity of the other. Nagkamali sa identity. And the last one, those subsequent marriages that are void under Article 53 of the Family Code. Under Article 53 of the Family Code, it provides that either the former party or either the former spouse may marry again after complying with the requirements of the immediately preceding article. Otherwise, the subsequent marriage shall be null and void. Now, the requirements imposed under Article 53 can be found in Article 52. That the judgment of annulment or of absolute nullity of the marriage, the partition and distribution of the properties of the spouses, and the delivery of the children's presumptive legitimes shall be recorded in the appropriate civil registry and registries of properties. Otherwise, the same shall not affect third persons. So if you will not perform those requirements provided for by under Article 52 of the Family Code, and you contracted a subsequent marriage, then you will fall on the 6 void marriages, which is subsequent marriages that are void under Article 53 are void marriages. So you need to fix things first before contracting subsequent marriage. The following marriages shall be void from the beginning for reason of public policy. By relationship between collateral blood relatives, whether legitimate or illegitimate, up to the 4th civil degree. Between step-parents and step-children. Between the parents-in-law and children-in-law. Between the adopting parent and the adopted child. Between the surviving spouse of the adopting parent and the adopted child. Between the surviving spouse of the adopted child and the adopter, between adopted children of the same adopter, and between parties where one, with the intention to marry the other, killed that other person's spouse or his or her own spouse. So those are marriages that are void from the beginning by reasons of public policy. Void marriages also include marriages contracted by any party who at the time of the celebration was psychologically incapacitated to comply with the essential marital obligations of marriage. So dito na pumapasok yung sinasabing psychological incapacity under Article 36 of the Family Code. And what are the requisites of psychological incapacity? Okay, number one, there must be a gravity, meaning it must be grave or serious such that the party would be incapable of carrying out the ordinary duties required in a marriage. The second requisite for psychological incapacity, there must be a juridical antecedents. It must be rooted in the history of the party antedating the marriage, although the overt manifestations may emerge only after the marriage. The last requisites for psychological incapacity is incurability, meaning it must be incurable, or even if it is otherwise, it is beyond the means of the party involved. We have a case, the case of Santos versus Court of Appeals, wherein First Lieutenant Luel Cap Santos married Julia, later on named Julia Santos. So their relationship at first is a happy relationship that they even bore a child. But the parents of Julia sometimes interfere with the marital affairs of Luel Santos and Julia Santos. To cut the story short of this case, Julia Santos went to the United States to work as a nurse, while First Lieutenant Luel Santos is with the Philippine Air Force or Armed Forces of the Philippines. So, Luel Santos demanded Julia Santos to go home to be the wife of Luel Santos. But Julia Santos stayed in the United States. When this Luel Santos chanced to go to the United States, because there is a program for the members of the Armed Forces of the Philippines in the United States, he tried to look for Julia, but Julia's whereabouts is unknown and communications is not available with Luel Santos to Julia. So Luel Santos filed an action to the Regional Trial Court nullifying the marriage of Luel Santos and Julia Santos, stating among others, the grounds is psychological incapacity. But the Regional Trial Court denied the petition of Luel Santos, petition to nullify his marriage to Julia in the grounds of psychological incapacity. A case also of Del Rosario versus Del Rosario, GR number 222541, promulgated on February 15, 2017, where the female spouse filed a petition to have her marriage with his husband declared void based on the grounds of psychological incapacity. The female spouse avers that the male is irresponsible, always engaged in drinking sprees, and a womanizer, while the female is earning for them as an overseas Filipino worker. Upon examination, the psychological examination yielded as a result stating that the male spouse is suffering from antisocial personality disorder. So the question there is, will the petition prosper? The court ruled in the negative, no? The case will not prosper Psychological incapacity, according to the court, as a ground to nullify the marriage under Article 36 of the Family Code should refer to the most serious cases of personality disorders, clearly demonstrative of an utter insensitivity or inability to give meaning and significance to the marriage. Emotional immaturity and irresponsibility could not be equated with psychological incapacity, as it was not shown that these acts are manifestations of disordered personality which make her completely unable to discharge the essential obligations of the marital estate. In case of Toring versus Toring, the court emphasized that irreconcilable differences, sexual infidelity or perversions, emotional immaturity, and irresponsibility and the like do not by themselves warrant the finding of psychological incapacity, as this may only be due to a person's difficulty, refusal, or neglect to undertake the obligations of marriage that is not rooted in some psychological illness that Article 36 of the Family Code addresses. So remember the requisites of psychological incapacity. It must be a gravity with juridical antecedents and incurability. So what are the things to be considered in invoking and proving psychological incapacity? The jurisprudential guidelines as laid down are as follows: that the plaintiff has burden of proof. Kung sino yung nagpetition, it should prove it. The root cause of the psychological incapacity must be medically or clinically identified. It must be alleged in the complaint, sufficiently proven by experts, and clearly explained in the decisions. Incapacity must be proven to be existing at the time of the celebration of marriage. Incapacity must be permanent or incurable. Illness is grave enough to bring about disability to assume essential marital obligations. Marital obligations refer to Article 68, that the spouses should observe mutual love, respect, support, and everything else under Article 68 up to Article 71 of the Family Code. Interpretations of the National Appellate Matrimonial Tribunal of the Catholic Church of the Philippines, while not controlling, should be given great respect. And trial court must order the prosecuting attorney or fiscal and the solicitor general to appear for the estate. Kasi laging kasali ang estate dyan sa nullification of marriage. For the next video, we will be declaring the contracting of a subsequent marriage while a first marriage is still valid and existing, and the effect of the appearance of a spouse who was declared presumptively dead for purposes of contracting a subsequent marriage. And we now proceed to legal separation and its grounds for our next video. Well, anyway, and then we proceed to property relations between husband and wife, and so on and so forth until sa support, parental authority. Madadaanan natin lahat po yun. And keep watching my videos, and if you are satisfied watching my videos, please don't forget to click the subscribe button and hit the notification bell para lagi po kayong updated sa ating videos. And feel free to share my videos. Maraming salamat. Mag-ingat po kayong lahat.